Good evening. Sorry for being late. Uh, Last time we had discussed about the jurisdiction of the Supreme Court, and just to recapitulate, last time we have discussed about the jurisdiction, original jurisdiction, then appellate jurisdiction, advisory jurisdiction, review, and curative jurisdiction. Just one second. So, how to put it on center?
Sir, one humble request, please, sir.
Yes, yes.
Sir, many of us actually got to know about the classes today itself.
Okay, okay, okay.
So I
Okay.
understand that it won't be possible to go in detail, but if we could have a very brief recap of the last class, that would greatly benefit a lot of us, sir.
Right, definitely. See, I will try to, right. See, basically, about the original jurisdiction of the Supreme Court, I have stated last time that the Supreme Court is having Article 32. The Constitution provides Article 32, Article 71, Article 131, Article 139A, 1 and 2 of the Constitution of India, right? So I will be bit slow also. Last time I got suggestion that I was going very fast, and some persons had inconvenience to because of that. So I would try to be slow also. So first thing, the original jurisdiction, as I said, Article 32, Supreme Court has got the writ jurisdiction, right? And I had said that normally questions are being asked about the writ jurisdiction of the Supreme Court prescribed under Article 32 of the Constitution of India, and about the difference between Article 32, which has been given to Supreme Court of India, provided to, and Article 226, by virtue of that High Court has been provided to issue writ. So this is called what we call writ jurisdiction. So normally I said that questions are being asked as to what is the difference between Article 32 and 226. So you'll have to write about that. That for violation of infringement of any fundamental right, you can invoke Article 32 of the. Want to go? Okay. In that case, if there is if fundamental right is violated, in that case only you can apply Supreme Court. You can come to Supreme Court and invoke the original jurisdiction of Supreme Court under Article 32. And for High Court's jurisdiction is broader. So I would suggest all of you to please go through Article 32 and Article 226. And because if you see Article 226, it starts with non-obstante clause, and it says that notwithstanding anything in Article 32. So notwithstanding means even if there is jurisdiction of Article 32, then also you can come to approach High Court for violation of your fundamental right. And then, as I said, that in fact High Court's jurisdiction with regard to issuing writ is wider, because it is not only in violation of fundamental rights you can approach High Court. For violation of any of your judicial right, you can approach High Court. But the thing is that against whom you are seeking the writ should be state. That is the mandate of law also, that it should be state within the meaning of Article 12 of the Constitution of India. He should not be a private person, right? So this thing I said that normally questions are being asked. And then I have also said that about the writs, habeas corpus, mandamus, prohibition, quo warranto and certiorari. So sometimes questions are being asked about the what is the meaning of the writ and when it can be issued. And sometimes it helps you in during drafting also, because sometimes you will be asked to draft the prayer of the writ petition, so how it has to be drafted. So in that sense, you need to know about the writs. I have already explained it in the last during the last course, last class, but this time also I would briefly tell you that mandamus is issued when you ask for any command to do some certain things and not to do. Mandamus, the meaning of mandamus is command, and habeas corpus is issued. Habeas corpus is issued in corpus is the body. So when there is an illegal detention or so, illegal confinement, you ask, you approach High Court and you can ask for a writ of mandamus. And as I said, prohibition, when any judicial authority or quasi judicial authority within the meaning of like when they act like in derogation of their power, or they overreach their jurisdiction, in that case you approach High Court or Supreme Court and you ask for a writ. And whenever you ask for a writ, then normally the drafting should be issue a writ in the nature of mandamus, or issue a writ in the nature of prohibition. So when you ask, you say that issue a writ in the nature of mandamus, directing the concerned respondent authority to do this thing, or like to do not to do this thing. So it should be like that, because I have seen nowadays writ petitions, I feel that this prayer clause sometimes is not in accordance with what should have been. So you should be very particular when you appear for drafting paper in Supreme Court. Sometimes in practice and procedure, I remember it was during 2013 paper, prayers were asked to be drafted during in the paper of practice and procedure also. So you should be, what I said, that you should be particular. And as I said, that certiorari is, you ask, you call for the record, and certain orders, if it needs to be quashed, which is illegal, in that case you ask for the writ of certiorari. And quo warranto, I have already said that it is, by what authority. So when any person is holding a public post, so this public post is very important thing, then only you can ask for a writ of quo warranto, otherwise not. So in B.R. Kapoor case, I had given that reference also. B.R. Kapoor, that is Jayalalitha decision, in that case a writ of quo warranto was asked for, and it was entertained, and she had to leave her office. I have also said that in P.J. Thomas case, Supreme Court had issued a writ of declaration. So when you ask for when you draft a petition, you also say that pass any other order, orders writ in the nature, or orders as this court deems fit. So you can ask for declaration also in certain case. So P.J. Thomas is example of that case. So and in the last during the last class, I have said that because Article 32 itself is in Part 3, so this itself is a fundamental right, and is basic part of the Constitution also. I have discussed about few cases where Supreme Court said that yes, you can directly come to Supreme Court, there is no bar as such. But subsequently Supreme Court said that first you should go to High Court, and then you should, after exhausting your remedies, you should come here in Supreme Court. I have spoken about a decision, Naresh Sridhar Mirajkar. If you want to write down this, this is a very important decision according to me. This is 1966 3 SCR 744. So in this case, Supreme Court has held that you cannot ask for a writ under writ. Sorry, yes, you cannot ask for a writ for quashing any order of Supreme Court or High Court. For constitutional courts, you can't challenge it. but there after that also in A.R. Antule case, the decision of 5 judges which was challenged which was Supreme Court certified, and in one more case, I remember this is Jumman versus State of UP. So this is 1991 1 SEC 752. So in this case, this I'm last time I have not mentioned about this case, but this case is an important case. In this case, Supreme Court entertained a writ petition under Article 32 and commuted a death sentence to life imprisonment. So Supreme Court said that since it's a violation of there is violation of there is question of Article 21. I don't know why it is 121. So therefore, Supreme Court entertained that writ petition. And interestingly, there is a 2008 judgment, Anita Kushwaha, because if you know that this transfer of cases was restricted, was not for section 25 and 406 was not applicable to the state of Jammu and Kashmir. So a writ was filed for transfer of the case and Supreme Court entertained. So if you can remember the name of that case, that is Anita Kushwaha. And normally questions are being asked about the curative jurisdiction. I have seen that it is being asked repeatedly. So you must know about the curative jurisdiction which Supreme Court has created for itself, and that is Rupa Ashok Hurra versus Ashok Hurra. If you want to note down the citation, you can note down also. This is 2002 4 SCC 338, and in this case Supreme Court has held that after dismissal of your review in circulation, so when it's not that review is dismissed in open court, if review is dismissed in circulation, in that case you can file a petition, a curative jurisdiction before Supreme Court. But there are certain prerequisites, prior conditions also. First thing is that the ground, you'll have to mention that the grounds what you are taking in curative has already been taken in review, and review was dismissed in circulation. So circulation, this concept, I don't know whether all of you know about it or not. See, circulation, dismissal in circulation, see, Supreme Court has got review jurisdiction by virtue of Article 137. So it's, after any order of Supreme Court, after its disposal, you can file a review petition before Supreme Court under Article 137 of the Constitution. So normally what happens that the review goes before the same judge. This is the rule. And normally it is decided in circulation. It means that yes, so circulation, so it means that there is no open court hearing. Like suppose you have filed one special leave petition before Supreme Court, and your special leave petition has been dismissed by Supreme Court. So in that case, you can file a review petition under Article 137 of the Constitution. So normally what happens that this your review petition will go before the judges in their chamber. They will not sit in open court. So we file application also. Normally I don't encourage to file review petition, and I also advise unless and until there are pressing grounds, like if you see review, there has to be some error apparent on the face of the record. These are the grounds of review. So that ground you can take from order 47, I guess, from CPC CPC अगर हो तो देना वहाँ so that those grounds are available to you, and so there should be some error apparent on the face of record, then only you should file review petition. Otherwise it is sheer waste of money, time and resources. So I don't encourage and I don't suggest also. And so what happens, you file review petition, it goes before the judges in chamber, there is no open hearing in court, and the judges decides it. So normally they dismiss the petition. This is, it's in one of the case, Supreme Court has observed that you are asking something is like you are asking something for the moon. So so review normally is dismissed. So what we do, we file an application also for open court hearing, but it's not that your open court hearing would be decided. So I was on the curative petition. So when your review is dismissed on circulation, then you can file it, and the grounds available are only two. You must remember this. First is violation of principles of natural justice, in the sense that order was passed without hearing you. You were not a party, and the order adversely affects you. And second is bias, that the judge was connected with the matter. There is apparent bias, and even after that this order was he decided. So this is something judicial. This is question of judicial propriety also. So then only you can file a curative petition, and curative petition has to be with a certificate by a senior advocate certifying that yes, you can file it. And this curative, he'll give a certificate that this is a fit case for filing. In his view, he has gone through the record, and in his view, this is a fit case for filing curative petition. And then curative goes before the three senior most judges of the Supreme Court. It is prescribed in the rules. So I would also suggest you to go through the Supreme Court rules also with regard to curative petition. This is order 48 of the Supreme Court rules, which says that it goes before 4 judges, and then your curative petition is decided. It is not as if that your curative petition will also be in open hearing. It may also be decided in circulation in chambers, meaning thereby there won't be any open hearing. It is up to the judges. If they are so convinced, in that case they can have a curative petition in open court. And then recent to my memory is that Union Carbide matter, which was heard and dismissed. And one matter today also I saw, and if required I will give reference to that order. And to my knowledge there is only one case where curative was allowed, and I had mentioned about that case in my last session also. It was Sughar Singh, 2010, 3 SEC 719. So I had I had discussed about the curative also. And I had discussed about the other original jurisdiction, like Article 71 of the Constitution of India, which is with regard to the presidential election. If there is any dispute with regard to president and vice president, in that case Supreme Court has got the sole jurisdiction. So when you see Article 71 of the Constitution of India, you should also see Order 46 of the Supreme Court rules, because Order 46 lays down as to how it has to be filed, like what is the how many electorate, and what is the court fees, like 20,000 is the court fees, and then sometimes questions are asked with regard to that also. And there is one act also with regard to presidential act, presidential and vice presidential act, and how it has to be filed. So it is also original jurisdiction. Last time I have also mentioned about Article 131 of the Constitution of India. You must see that article suit is filed before Supreme Court when there is a dispute between the union and the state, and two state and union and state with one side and other states in other side. So Article 131, the need of Article 131 was because our country has a federal structure. Constitution provides a federal structure, and there is state list, there is union list, and there is concurrent list. So sometimes there are conflicts between the list as to which has got what power, and therefore dispute arises. Earlier also many times disputes have arisen, and suits were filed before Supreme Court, and suit may be with regard to question of law or fact and not otherwise. And some legal issues where some legal right is involved, in that case only the suit will be entertained. And I also said that state is stricto sensu state. It's not state within the meaning of Article 12 of the Constitution of India. And one more thing I wanted to say. Yes, sometimes, about the water thing also, I had said that with regard to water dispute, there is a provision in Constitution, Article 262. In that case, suit is not entertained. Suit will also be not entertained when there is some treaty, because whoever, like you all who are preparing for AOR examination, in that case you should see Article 131 of the Constitution. Suppose there is some treaty, in that case, no, 131 would not be entertained. And one interesting thing is that if there is like any dispute likely to arise also, in that case President can ask for an opinion from Supreme Court under its advisory jurisdiction. So that can also be done. It is so. And I will come to Article 143 also. And before I go further, I would like to tell all of you that Supreme Court has been given exemplary power. In my opinion, it is Supreme Court, like in any other country, no other Supreme Court has got such power. That is my view. And according to me, Supreme Court is not only a court of law but also a court of justice. And this power has been given to the Supreme Court by virtue of Article 242 of the Constitution of India. Sorry, 142 of the Constitution of India. 132 is something where Supreme Court can pass any decree, order for doing complete justice in a matter. And Constitution, where is that? Just 1 second. Please give me 1 second. Because 142 is in two parts. Yes, it starts with enforcement of decrees and order of Supreme Court and orders as to discovery. So part 1 says that in exercise of its jurisdiction, it may pass any order, any decree for doing complete justice in a matter. So, and such type of orders have been passed. See, normally also for getting a divorce decree when a case is filed before Supreme Court, there are innumerous instances where Supreme Court has invoked its jurisdiction under Article 142 of the Constitution of India and has granted divorce and has settled. So in many matters where the cases are not compoundable, I know High Court also exercises its 482 or 151, but this is such a power which is extraordinary, because Union Carbide case, if you remember, in that case criminal cases were filed against Union Carbide and its promoters, and in that case Supreme Court had set aside all those criminal cases, and some settlement was there and very controversial also. So, but Supreme Court exercised its power, and 142.2 you should see, it is very important. Subject to provisions of any law made in this behalf, Supreme Court shall, as respect to whole territory, have all in power to make. So 140, as per 142, Supreme Court has got the power to make any order for the purpose of securing attendance of any person, the discovery or production of any document, or investigation or punishment of any contempt of itself. See, I was on 32, and so what happens, and now it is what happens that, when you file a writ petition, and writ petition suppose is entertained by Supreme Court, and if the writ petition involves some disputed question of fact, right? In that case, Supreme Court can pass order under Article 142.2 to, Supreme Court can set a commission, can order for a commission who can inquire about the disputed questions and may report to Supreme Court, and accordingly Supreme Court can pass order. So various times this has been exercised with Article 32 of the Constitution of India, like Bandhua Mukti Morcha case and other cases also. And recently I will tell you about that. Just 1 second. Justice Nagaratna's judgment, Bilkis Bano case also. So you must see that judgment. That judgment is very relevant judgment, and we can discuss it in our next lecture. So that judgment also, in my view, you should see. And before proceeding further, I would like to say that on many occasions questions have been asked as to what is the substantial question of law. Because this phrase you will find in Article 132 and Article 133. Article 132, you will find that an appeal lies to the Supreme Court against judgment, order, decree of a High Court, where High Court gives a certificate. So what is that certificate and what is that substantial question of law? We must know. So High Court gives a certificate that there is substantial question of law to the interpretation of the Constitution is involved. Then only High Court can give a certificate under Article 132. So for substantial question of law, you must see Article 147. Article 147 of the Constitution is interpretation with regard to substantial question of law, and it says that that question must relate to like the interpretation of the Government of India Act 1935. See, prior to our constitution, it is our country was during Britishers' time. It was governed by the latest was this Government of India Act, and then thereafter Indian Independence Act. So and the obviously the Constitution of India. So question of law relating to that thing, right? And it should be a question of law. It should not be a question of fact. And there is one judgment of Supreme Court which is very important judgment. You must note down this judgment. This is Sir Chunni Lal Mehta. Sir Chunni Lal Mehta case. This is 1962 supplementary 3 SCR 549. You can, I think you all can do one thing. We can have a WhatsApp group. You can coordinate with Shruti ji so that if any material is there, I can provide that material to you. Or like if there is any question and if I find time, then I would try to answer that also. So that judgment is, we can save our time also, because I'll just say about that judgment and you can get it in the notes. So that judgment is Sir Chunni Lal Mehta, 1962, supplementary 3 SCR 549. So it says that it should be a question of law, not of fact, and it should be a question of general public importance, right? Where directly and substantially rights of the parties are involved. And it should be an open question not settled by Supreme Court, by Privy Council or by Federal Court, and not free from difficulty or call for discussion of alternative views. So substantial question of law, this is normally it is being asked. So in that case, you will have to refer to Sir Chunni Lal Mehta's judgment, and that question should not be an open question. That question should be an open question in the sense that if the question has been decided by Privy Council, or if the question has been decided by Federal Court or by Supreme Court, in that case, it is not a substantial question of law. And substantial question of law, as I said, to the interpretation of the Constitution is obviously, as it says, it should involve the interpretation of our Constitution of India or Government of India Act or the Indian Independence Act. So we had covered, last time we had covered Article 132, Article 133, and I had said that questions are normally asked with regard to what is the distinction between 132 and 133. You should know that we can discuss it in some in some other time. So now the other appellate jurisdiction, now we are on the appellate jurisdiction. The other appellate jurisdiction provided by the Constitution of India is Article 134 of the Constitution. It says there are three things. It says that appeal lies to the Supreme Court if, like in a judgment of acquittal passed by Sessions Court, if it has been reversed by High Court and High Court has awarded a death sentence, in that case appeal lies to Supreme Court under Article 134(1)(a). Appeal lies to Supreme Court when High Court withdraws a case from Sessions Court or from trial court, takes it to itself and passes a death sentence. In that case also appeal lies to Supreme Court. And C, High Court gives a certificate under Article 134(a) that it is a fit case for an appeal to the Supreme Court. Now, before going further, I had said that two things you'll always find during appellate: that substantial question of law and the certificate. So the provision of certificate is under Article 134A, where High Court, while passing its judgment, order or decree, final order, because the conditions has to be fulfilled as per Article 132, 133, 134. So like 132, High Court will have to give a certificate stating that the question involves a substantial question of law to the interpretation of Constitution, and in its opinion, and as I said, that in civil matter, that Article 133 certificate can be given, and High Court would opine that it is a substantial question of general importance, and in the opinion of High Court, this question needs to be decided by Supreme Court. And I tell you, there are certain instances where certificates were given by High Court under Article 133 and 132 also, and Supreme Court deprecated the practice, saying that, see, if you are able to decide it, you decide it. If it doesn't mean that you are incompetent to decide a question. So before giving a certificate, you should understand the significance of it. So normally you will not get certificate by High Court, normally stating that all these things, substantial question or 33, and certificate under Article 134 1C is simply, High Court says that it is a fit case for appeal to Supreme Court. In that case also certificate is granted. And how this certificate is granted? Like High Court on its own motion can give, while passing the judgment, High Court without any application can give a certificate stating that this is involved so and so, and High Court certifies about that thing, and then the appeal to Supreme Court would be maintainable. There is no doubt about it. So, and on its own motion or an oral application, like the parties there can contend, the litigant, the who are appearing before Supreme Court can say that that certificate be given. In that case also, certificate can be given to Supreme Court. So I was on the certificate, and I said that also, that the practice of certificate, there is one judgment I remember, Jyoti Mittar, I guess. So in that case also I had said that it has been stated that normally it should not be granted unless the conditions are fulfilled. And 134, I was on 134. So I said about these three conditions. So here this provision is provided by virtue of Constitution, and you must also see section 379 of CRPC. Like 379 of CRPC says that not only in case of death, in those cases also where High Court has awarded 10 years or more, you can come to Supreme Court. So there is an important and interesting thing also, because if you see Article 134B, it says that High Court withdraws a case from trial court, decides it and passes death sentence. It means that High Court has got all such, Supreme Court has got all such powers. High Court has got all such powers where trial can be held. So I was discussing about A.R. Antule judgments. Sometimes you will be asked about, because because it is a very controversial judgment, A.R. Antule judgment, 7 judges bench, setting aside a 5 judges bench. So sometimes questions are asked, and you must know, because in that case Supreme Court had not said that whether High Court has got that power or not, because Constitution provides that power to High Court for trial of any case, and it can withdraw it to itself. So High Court has got the power, but the issue was that with regard in AR Antule, the issue was whether there is a violation of Article 14 in the sense that some other persons are getting an opportunity to, like, their trial would be conducted before sessions court or trial court, and he has got an opportunity to file appeal before high court. But if the high court tries any case, in that case he does not have any opportunity to file an appeal to Supreme Court. I think that this is not a correct notion, because there is one section in CRPC. If you see, this is 374 of CRPC. This is very important. Just give me 1 minute. Where it is? Evidence. In that case, there is provision for appeal to Supreme Court. By virtue of that section, just compounding section, I said 374. Yes, if you see section 374 of CRPC, it says any person convicted on a trial held by a high court in its extraordinary original criminal jurisdiction may appeal to the Supreme Court. So the words are, if any person is convicted on trial held by a high court. So he has got a right to appeal to Supreme Court by virtue of section 374(1) of CRPC. And as I said that when you see article 134, you should also see section 379 of CRPC, where the similar contents are similar, but in those cases where the punishment, the conviction, the sentence is more than 10 years, in that case an appeal lies to the Supreme Court. And I had also stated about the instances where statutes, there are statutory provisions like insolvency and bankruptcy code, and there are NGT, then Competition Commission of India Act also, there is provision of statutory appeal. So a question arose before Supreme Court as to about the disposal and the manner of the appeal before Supreme Court, as to how it has to be decided. So you can write this judgment. I will discuss this judgment while discussing about Article 136. O.N. Mahendru, in that case, 1968 to SCR 709. In this case, Supreme Court says that the statutory appeal can be dismissed summarily without issuing notice. So when your appeal, you file an appeal before Supreme Court, it's not that in every case Supreme Court will admit your appeal, Supreme Court will issue notice, will admit your appeal and will decide it. It's not that. Now we should come to Article 136 of the Constitution of India. In my view, this provision is bread and butter for many lawyers who are practicing in Supreme Court of India, and it starts with a non-obstante clause. It is not trammelled by any other statutes, And it starts with like, notwithstanding anything in this chapter, the Supreme Court may in its discretion. So, Supreme Court may in its discretion. This is a discretionary jurisdiction. Grant special leave to appeal from any judgment. See, this is very wide. Why I am saying that grant special leave to appeal from any judgment, decree, determination, sentence, or order. So there are 5 things you must remember. You can mug up also, where you can file it against judgment, decree, determination, sentence, order. Earlier you would have seen that judgment, decree, order, judgment, decree, sentence, like that thing, right? Passed by any court or tribunal constituted by or under any law relating, passed by any court or tribunal. So such a wide power that such things, such judgment, order, determination, you can file special leave to appeal against these orders passed by any court or tribunal except tribunal for armed forces. You cannot file special leave to appeal against an order passed by armed forces tribunal, except that you can file special leave to appeal against any order, judgment passed by any court or tribunal. So this is something, but this discretion is discretionary, though it is very wide. Sometimes even special leave to appeal SLP against the order passed by CGM has also been entertained by Supreme Court. So, and Supreme Court has got plenary power with regard to that. So there is one case law, L. Chandra Kumar. This is 1997 3 SEC 261. 1997 3 SEC 261. In this judgment, Supreme Court has said that Article 136 is part of the basic structure of the Constitution. So in that case, it is not open for the legislature to take away the jurisdiction of Supreme Court. This is a very important judgment, where CAT was like constitutional amendments were made with regard to setting up of Central Administrative Tribunal, and which was and earlier. So what was happening, that the power was given exclusively to Supreme Court, like power was given to the tribunal, and appeal lied before Supreme Court only. So in this judgment, the Honorable Supreme Court said no, this is because you cannot bypass High Court, because in that case, one must go before High Court under Article 226, and then you cannot bypass it. So this is the essence of that judgment, and discuss about Article 226 and Article 136 also. This is a very, very important judgment. And there is a judgment, Bharat Bank. So now the question arises as to what is the meaning of tribunal. Like because I said that passed by any court or tribunal. So what is the meaning of tribunal under Article 136? For that, you must see this judgment, and if you write about this judgment, you will get very good marks. This is Bharat Bank Limited, 1950 SCR 459, 1950 decision. So it says that for meaning of tribunal under Article 136, it should be like the tribunal has to perform judicial function, and it should have all the trappings of court. Trappings of court, you may see, what are the trappings of court. So Bharat Bank said that, then only it would be within the meaning of tribunal under Article 136. And then question arose as, what about arbitral tribunals? Whether arbitral tribunal would be covered under Article 136 or not. So if you say that Article 136 can be entertained by Supreme Court against any order passed by any court or tribunal, then uh, in Hind cycles, Supreme Court held that no, arbitral tribunal is not a tribunal within the meaning of Article 136. So this is the judgment Hind cycles 1963 supplementary 1 SCR 625. 1963 supplementary 1 SCR 625. So this judgment said that no, arbitral tribunal is not a tribunal. And there is a judgment Indira Kaur 1988 to SCC 488. So this judgment says that there is no fetters on the Supreme Court on its power under Article 136. So you cannot say like no, you can't do it, like concurrent findings of fact. So suppose trial court, then first appellate court, and then high court, there is concurrent findings of fact in favor of one person, and it is before Supreme Court. So normally Supreme Court does not interfere, that I have seen. So but in this judgment Supreme Court says no, see, if there is perversity and if we see that there is manifest injustice, in that case we will interfere. You can't say that since there is concurrent findings of fact and therefore Supreme Court is barred. No, you can't raise this plea. We can't fold our hand and we can't be helpless spectator. These are the words in that judgment. So this is a judgment which I don't know whether it is very important or not, but and then who can approach Supreme Court? Whether a person who is not a party to the list, never a party to the list, whether he can file an appeal, special leave to appeal before Supreme Court. So sometimes you may be asked this question and the answer is yes. Those persons can also, that party can also file Supreme Court. Supreme Court has not prohibited anybody to approach Supreme Court. And Supreme Court has not conferred power on anybody to approach Supreme Court. Like this is something, special leave to appeal, and this is something, the wordings are like that, it's a plenary power, not circumscribed by any conditions except this armed forces thing. So there is a judgment which is PSR Sadanantham versus Arunachalam. This judgment you may note down. This is 1979 to SCC 297. So this judgment where a person who was not even a party, in that case Supreme Court entertained, and whenever we file some SLP when our client is not a party, we quote this judgment and we say in that judgment, but you'll have to establish your case as to your case is made out and you are aggrieved by that judgment. So in that case you can take help of this judgment Sadanantham. And there is one more judgment. I remember this is judgment. This case was filed by V.S. Achyutanand, who was the Chief Minister of Kerala versus K.G. Balakrishnan, if I remember correctly. So in that case, Balakrishnan was acquitted by High Court, convicted by trial court and acquitted by High Court. In that case, that acquittal was challenged by Achyutanandan and Supreme Court reversed that acquittal and convicted that person. So in many instances, when there is pressing need, when complainant feels that state has not done justice with its case, In those cases also, I have seen many times SLPs have been filed and SLPs, special leave petitions, have been entertained by Supreme Court of India. Yes, there are various judgment, because see, this is when we file special leave, just 5 minutes and then I'm done, and then we can discuss in our next class. What was saying that, yes, I was saying that normally most of the cases what we file before Supreme Court, because when you don't get any certificate from Supreme Court, in that case you ask for a special leave to appeal against that judgment or order. And you'll see that normally when cases are listed before Supreme Court, I would not, won't be right for me to give any data, but you would find that according to the what I perceive is that some 80-90% cases are dismissed on the threshold, on the very first date. So why is that? Why all those cases are dismissed? Because see, this is special leave to appeal and this is under discretionary jurisdiction. So Supreme Court has got discretion whether to entertain or not. Sometimes Supreme Court sees that there is some illegality in the order of High Court, but in that case also Supreme Court normally shuts its eyes and says all right, because it is not possible also to entertain all those cases. So while drafting special leave to appeal, you should be very particular about the error which has been there error in the judgment, and that error is relating to a substantial question of law, because you are asked to draw the question of law. Even in criminal matters you are asked to draw. So you draw also. So you'll have to be very particular about that thing, and then only, and if Supreme Court finds it fit, in that case only notice would be issued. Otherwise your SLP would be dismissed on the very first date. So I would we would discuss about doctrine of merger and about other aspects in our next session, and we'll, I think, cover our topic. We'll try to cover our topic in our next session. Thank you so much. And anybody want to ask any question with regard to the,
Pardon me, sir.
yeah, please.